Good evening and welcome to the October 20th, 2015 Planning and Zoning meeting. If you could please stand for the Pledge of Allegiance, then a moment of silence.
Pledge allegiance to the flag of the United States and to the republic for which it stands, one nation, under God, with liberty and justice for all.
Could we please have roll call from left to right?
Anthony Sutton.
Mike Dolan.
John Grant.
Jean Servine.
Edward Mead. Carl S. Moore.
Tom Nickel.
Tom Panzella.
Jim Quish.
I am Ben Gettinger, also present. David Sulkis, City Planner. Phyllis Leggett, Board Clerk. I believe we have a motion related to the order of the agenda.
Yes, I'd like to move that we move the agenda so that 7 Pond Point Beach Drive and 1052 Boston Post Road are moved to the beginning of our agenda. Those people, the representatives, are here.
Well, you lost your opportunity. We'll keep the agenda ordered the way it is. The first item on the agenda is 824 approval for the city's acquisition of 60 Hellwig Street. Mr. Sulkis?
No, I was just going to say that I know I saw the applicant for 1052. He might not, because of the crowd, they might not have been able to hear what was going on. So you might, if you want to reorder the agenda. I mean, basically the chair is asking if the applicants for 7 Point Beach Drive are here, and 1052, yep, so you're here in 1052 Boston Post Road. They're both here, Mr. Chair. So.
Okay, and my understanding is that those two are going to be quick applications. So with Mr. Servine's motion, do we have a second? Having a second, any discussion? Seeing none, all in favor? Anyone against? Motion passes. Continuing with the first item on the agenda, 824 approval, acquisition of 60 Hellwig Street. Mr. Sulkis, any comments on that?
No, the package is fairly self-explanatory. The city would like to acquire that property as well as 159 High Street.
We'll do them both together to save some time. Any discussion on the items? Seeing none, would anyone like to make a motion? Mr. Nickel?
Yeah, I'd like to know more about 159 High Street. Seems like that there is a house or whatever that's occupied. Why do we want it?
I believe the city attorney is here.
Good evening, Mr. Chair. Through you to Mr. Nickel. It's my understanding that the property owner of the Hellwig Street property contacted the city to inquire whether it would be interested in purchasing, spoke to the mayor. I'm not aware of any specific plans for the property other than it's adjacent to existing public parking located across the street. Other than that, its proximity to Listman's Landing and future available downtown parking.
Yeah, I can understand that house, but I'm more interested in 159 High Street.
Oh, I'm sorry. 159 High Street is similar in nature in that it's adjacent to property that we just closed on, the referred to as the DeLeo piece, the High Street piece, where the red buildings are located, which are adjacent to Railroad Avenue. The city closed on Friday pursuant to a state grant. So the city is now the owner of those two parcels. We hope to close within the next 2 weeks for the River Street properties, which connect from High Street to River Street. So the High Street property, similar to the Hellwig property owner reached out to the city, was interested in selling to the city without putting it on the market. It would just add additional parking for the railroad station.
Any further questions? Seeing none, would anyone like to make a motion? Mr. Quish?
I would move to approve the sale.
Second.
Having a motion and a second, any discussion on the motion? Seeing none, all in favor?
Aye.
Anyone against? Those two pass. The next item on the agenda is 7 Point Beach Drive, Zone R-7.5.
Evening. It's a coastal area management application to build a single-family residence, 7 Point Beach Drive. All the approvals have been made so far, all the channels have been gone through, and I'm open for questions.
Thank you. Any comments from staff?
According to Mr. Harris's staff report, staff finds the development satisfies the coastal site plan provisions of Section 5.12 of the zoning regulations and recommends approval.
Thank you. Any questions from the board? Mr. Nichol.
Yeah, on that site, I noticed that seawall needs some help.
I believe there was some work done to it before the storm. And as far as erosion goes, I mean, there's a couple of cracks in it, but I don't see a problem with erosion or anything like that.
Do you have any intention of taking care of those minor cracks that are getting bigger and bigger?
There's nothing in my contract to do that. I'm the contractor on the job. I'm in charge of the whole project. I'm sure it'll be addressed before the project is completed.
Thank you. It'll be addressed.
Any further questions from the board? Seeing none, would anyone like to make a motion? Ms. Servine?
Since there don't seem to be any problems with the site plan and the staff has approved, I would make a motion for approval.
Having a motion, do we have a second?
Second.
Having a motion and a second, any discussion on the motion? Hearing none, all in favor? Anyone against? The motion passes. The next item on the agenda is 1052 Boston Post Road, Zone ICD.
Thank you.
Hi, Mr. Chairman. My name is Philip Kraft of 1052 Boston Post Road, otherwise known as Howard Johnson's, and I'm here to extend for 6 months the special permit that was issued to me September 3rd of 2013. It's the rock crushing and excavation of that property. I'm about 93% complete at this time. We've moved out a total of 234,000 tons, and we're almost there. We'd like to clean it up and present the site.
Thank you. Any questions or comments from staff?
Yeah, when the applicant originally came before the board, they did tell the board that they thought the original completion of the project would take 18 to 24 months. In discussions with Mr. Kraft, he told me that that probably would have been reasonable, but the nature of the equipment that does this work, I guess it breaks down often, so that's why they haven't completed the project, and that's why he's asking for that extension.
How much longer do you anticipate?
From a practical point of view, the crushing should take about 30 days. And the blasting's we probably about 4 days of blasting. We blasted 94 days so far, so we're nearly done.
Thank you. Any additional questions? Mr. Nichol.
Is 6 months enough to get this done?
Well, I originally had thought it's a 2-month job, but to be careful, just not to have to come back here, 6 months would be plenty comfortable for the crushing and the rock removal.
Any further questions? Seeing none, would anyone like to make a motion? Mr. Nichol. It's not a public hearing. It's just a minor amendment to an application. Sir, if you think there's a problem, then you should go to the zoning enforcement officer and make a complaint. We're limited just to the minor amendment to the application. Well, through me, could you address that comment? Is it true you're doing things that the permit does not include?
No.
Okay.
And we've been monitored by the state. It's regulated by the state as well as the zoning officials, and we've met every obligation. We have a water truck on the site. We have sprinklers on the site. We've tried to accommodate everybody. We had hours of operation that were originally put in this approval. We've stuck by those, and we just want to finish quickly. We're all set up. We have it there. We're 30 days, I think, from finishing.
Having a motion, do we have a second? I'll second. Mr. Grant with the second. Any discussion on the motion? I'll just simply urge the applicant to hurry up, please. Obviously, there's some displeasure from the neighbors, so do this as fast as we can.
And we appreciate that. We've handled all the phone calls, and we address it. We go over there before we blast. We identify the day, the time, and the city calls, the fire department calls. So it's, and we probably only have a couple of days of blasting. So.
All right, having a motion and a second, any further discussion? Seeing none, all in favor of the motion? Anyone against? Mr. Quish is against. Motion passes.
Thank you.
The next item on the agenda is 86 Pond Point Avenue.
Mr. Chairman, good evening. I'm Attorney Matthew Woods, trial counsel for the City of Milford. The two plans to your right are plans that you've seen in executive session. By way of background, the application was filed to construct 22 additional units at the subject property where there's already one single-family house. This board denied the application. An appeal was filed in Superior Court across the street and then transferred to Superior Court in Hartford, where Judge Marshall Berger on June 29, 2015 sustained the appeal. We filed what's called a petition for certification because in a zoning appeal, unlike a regular lawsuit, you do not have a right to appeal automatically. You have to get permission to appeal. You have to have two judges on the appellate court vote to allow the appeal. Doesn't mean you'll win the appeal, but it means you at least get into the batter's box. We do not have a decision yet on the petition for certification. The settlement that is before the board tonight is the left side, which basically reduces the intensity of the development from a total of 23 units to 16 units, which is a 30% reduction. It reduces the impervious surface from about 57,000 square feet to 37,000 square feet, which is a 35% reduction. It changes the development from a common interest, basically a rental unit, to standalone with 4 rental units, which would be the affordable units at the 80% level, and it is more in line with the nature of the neighborhood. So the decision that the board has to make tonight is whether to reject the settlement and roll the dice with the appellate court. I can say that Judge Berger has issued 22 decisions on affordable housing cases. Only 2 have been appealed after petitions for certification were granted, and he was affirmed on both of them. Or you can vote to approve the settlement, and then it goes before Judge Berger on November 12 for him to consider whether to approve the settlement. So that's the choice before the board tonight. Accept the settlement or reject the settlement and wait for the appellate court. We are not optimistic that we would ever prevail at the appellate court level. We're not even optimistic that we'll have the petition for certification granted. And if the petition is denied, then that's the end of the case. The developer can build the 23 units.
Thank you. And just procedurally, it's my understanding that this is down for public comment, which is different from a public hearing. Can you just explain the difference and the purpose of the public comment?
Judge Berger goes beyond what the practice book requires, what the general statutes require, and wants local planning and zoning boards or commissions to have some input from the public, generally the neighbors, as to whether or not to approve a settlement. That's not to say that if a number of people come up and oppose a settlement or are in favor of the settlement, that would make a difference. But the judge does want the board to have an opportunity to listen to what the public has to say, and the judge wants the public to be able to briefly articulate what their concern is, either for or against the settlement. So it's not a public hearing, but it's just public comment.
Regarding the settlement?
Correct.
Thank you. So procedurally, what's next, Attorney Wood?
I think the board should allow the public to comment.
All right, we will open this up for public comment. You have 3 minutes, and if you could please try to do your best to keep it under 3 minutes. If you don't forget to state your name and your address, and try to be as courteous as possible. And we'll start with anyone in favor of the settlement. Seeing none, we'll open it up to people that are opposed to the settlement.
Hi, Christine Baumuth, 23 Dawes Street. I'm opposed to it. I mean, he's going from 23 to 16. It's 2.5 acres of land, and Sonia's having the same problem with 4.5 acres of land and only 13 buildings. Where are you going to stop these builders? Look at where St. Mary's is, over on Gulf Street. That proposition over there, that's 830G too. We're going to be afraid to sell our homes, thinking that builders are going to come and take a home and put 3 or 4 units on it. Where is it going to stop? It needs to stop here, and it needs to stop now. Thank you.
Ann Lambier, 17 Dawes Street. I'm opposed to this because the police, the fire, all the approvals, they're just rubber stamps. They're not going out and actually doing the studies. When we were here for the hearings, the traffic study alone was farcical. It was bought and paid for when we had one of our neighbors who actually went and did the work, pulled up the accident statistics, the traffic patterns. People in the neighborhood showed what a nightmare it already is for traffic, and that's not taken into account. Well, we also had someone who called the Department of Environmental Protection, and the woman actually admitted she didn't even get up from her desk to do anything. She just signed the paper. How can you rubber stamp these kind of over-dense developments without even doing the work behind it? It's wrong. It's terrible to impose this on the taxpayers that already live in this town. I mean, what is that zone for? 4, 6 houses maybe? And you're going to squeeze 22 units in there without even taking into account the neighborhood. To me, it's despicable. I mean, I understand 830G, has good intentions, but it's being abused. You can see it all around Milford now. They already mentioned the one by St. Mary's. God help anybody who tries to get out of that parking lot in the morning, because I drop my daughter off to school at St. Mary's, and I can tell you it's impossible to get out of the parking lot of the church, let alone trying to get out there. And another thing too, why would anybody want to move here? You can't feel safe in buying a piece of property because anybody can buy your next door neighbor's plot and say, oh, 830G, we want to put 6 units here. I'm lucky. I can get out of this town soon. My kids are almost done with school, but I feel sorry for anybody else who wants to buy something but can't feel secure in knowing that the neighborhood that they're buying into is going to remain single-family houses or duplexes or whatever, but not this type of dense overpopulation or overbuilding on every single piece of green that's left in Milford. It just has to stop somewhere, and I'm hoping that people in Milford will actually do something about it, because It's really sad that, I mean, we have builders coming in from all over the state now, 830G, 830G, but this one here is being done by someone who actually lives in this town, and I think it's a travesty and it needs to stop.
Good evening. My name is Bob Sandman, and I live at 58 Pauline Street. I bring to this meeting one simple question. What has happened to make the city of Milford ground zero for 8-30G projects? I spoke to the previous Planning and Zoning Board, the Board of Aldermen, and the mayor on several occasions about my neighbor's concern over the Kohlberg project at 86 Pond Point Avenue. My wife and I also attended the appeals court hearing up in Hartford, hoping that the judge would rule in favor of the city. What we came away with was a major disappointment of the results. The judge concluded that the city did not provide sufficient new information that would alter his decision. It was felt that the prior Planning and Zoning Board did not offer a current traffic study, no additional reasons for denial, and gave the impression that it just folded under the cloud of 8-30G precedents. My neighbors and I are not against affordable housing in our city. However, we are vehemently against jamming 2- to 3-story housing in neighborhoods that are occupied by ranch-style homes. I am asking this Planning and Zoning Board to closely review any proposals by Kohlberg as it applies to 86 Pond Point Avenue and deny any request for high-density building on this property. The citizens of Milford are extremely upset over the rash of new 8-30Gs being presented to the zoning board by local and outside contractors who feel that Milford will just fold and not fight back to reduce these new applications. How prepared is the city to fight these? A suggestion that I am offering is have our city attorney offer instructions by either himself or an 8-30G expert as to what and how a local zoning board can present a tight case should it go to the appeals court. The judge we heard implied that our Planning and Zoning Board did not do their homework. It is time to correct this issue. In closing, I'm disappointed that Milford residents such as the partners in Kohlberg would want to destroy a neighborhood such as ours just to make a profit. I'm sure they would not want or allow these where they live. Thank you.
Steve Fricke, 28 Lindy Street. I just have two quick things to bring up. One is on this new site plan. This is private property, so the town is not responsible for plowing this. When this snows and they come down this street with the snow plow, are they just going to push it straight across Pond Point onto the house across the street and leave the ruts, which is against the law in this town to plow across a street? So where is that snow going to go? The other thing is the traffic site that was done where they counted the cars between Hoover and Dawes does not count all the cars that go by this site. I live on a corner of Lindy and Marino, and between 7 o'clock in the morning and 7:30, I could count 74 cars that go by my house that did not go across their counting strips. So they're way off on how many cars come down Pond Point. Put their measurers in front of their property, count your cars there, see what the traffic is on Pond Point. You're not going to get out of that in the wintertime when it's all iced up, and in the morning the traffic. Very, very bad planning. They need to do their homework better, and if they're going to measure things, measure it where it should be, and check on the snow. Your own laws in this town says you cannot plow it across the street. Where are they going to put that snow? Thank you.
My name is Susan Simmet. I live at 200 Pond Point Avenue. I've been here for all of the hearings. I attended the court hearing in Hartford. While unfortunately I have to agree with Mr. Woods that our chances of winning that hearing are very slim, I am not in favor of either project. I understand that you as the board have to follow the law, so perhaps our ire is a little misplaced. But I do ask that in the future, even though perhaps we will lose and we will have to accept the buildings that Mr. Colucci and Mr. Bergami are going to inflict upon our town, upon our street, creating more problems, I implore you, please, in the future, there's an ordinance sponsored by the Board of Aldermen to change that so that you can ask for a traffic study. When the traffic information was first provided by Mr. Colucci in the original hearing, the neighbors on Palm Point Avenue we were just amazed. How could this possibly be? And we found out that he actually did a study between one street and the other and not up the street. When we went to the court hearing, Mr. Woods, I'm sure, can confirm that the judge actually said there was case precedent that planning and zoning and the residents, who are considered non-experts, their testimony could be used in determining whether or not traffic was a safety issue. Unfortunately, the experts provided by Mr. Colucci, who provided a study that we perhaps found fault with, and the city did a pro forma, and that was the mayor's response to me when I said, how could the Traffic Commission have ever approved that? I've lived on Palm Point Avenue for 51 years, and you're telling me you approved 22 units? And he said, well, it was a pro forma study. And when we asked for a study before the hearings all concluded, he said he wasn't able to do that because it was likely to go to litigation. So I'm saying you have an ordinance that would allow you from now on, when anything comes before you that is denser, whether it's 830G or not, because there's other projects that are asking for zoning changes, if it's more dense, ask for a traffic study, and then the developer has to pay for it. So at least do a bona fide traffic study, because if we had gone into court with Mr. Woods and you had denied it because of the city's traffic study and us and you, chances are that his traffic study would not have held water. So we're all going to lose, unfortunately, because the city did not do their homework. So I'm against both of those projects. And by the way, Ms. Lambiase didn't mention the retention pond, which will be in her backyard now. So who will be responsible for the retention pond? Because in the original project, it was going to be the condo association. So now it's going to be in the backyard of 1.5 of those people that are going to buy those units. Okay, so just want to let you know, in the future, use that ordinance and do your homework, because you can win on 830G if it's meant to be, if there really is trouble with that development. So please do your homework in the future. Thank you.
Hello, Barry Laws, 41 Pauline Street. I'm adjacent to the property. The biggest issue I have with this is the water. We already get a lot of water in our backyard, and the drainage is incredible. It's like one storm, I was in a canoe, I'll show pictures of it, in my front yard because of the rain. And if he's going to put all that property, all those buildings in there, it's definitely going to affect the water drainage. Other testimony in previous hearings, people have said that they'd had similar issues with similar contractors, and they had water coming into and mud coming into their basements. So that is going to cause an issue in our yards, but it's also going to cause water drainage into the street and ice on that hill in Palm Point Avenue, and it's going to be traffic accidents. I just see it as a lot of issues there. The other thing is this new plan that came forward, we have no idea what it looks like, what other construction things they have in there, what kind of drainage system they have in there. So springing this on this last minute like this is not fair either. So I think this all should be considered and maybe given more time and consideration. Thank you very much.
Hi, Suzanne DeBias, 77 Lindy Street. Here are the pictures that Ken was just talking about of the water on Pauline Street. This is not a hurricane, this is a rainstorm. Okay, I am opposed to the 23 units and the 16 units. We all already have water problems in our neighborhood. Tearing down every tree on that property will make it worse. The cellars already get wet in a rainstorm, and the streets as well, and all the yards. Everyone in Milford should be concerned about what our city is going to become in the near future if this continues. Every time a property goes up for sale, will 8-30G be going in there next? No, I am opposed.
Hi, I'm Robert Lucas. I live at 99 Palm Point Avenue, which is diagonally across from the property. I grew up with the Williams boys. I lived here for 43 years. Previous, till I was 20, I lived directly across at 89 Palm Point Avenue. My grandparents, both sides, been here since the 1900s. I know that property like the back of my hand. When I was a kid, Clayton and I used to drive cars on this and get them stuck in the woods because of the mud, the water. I never knew all the people in the back have pumps in their basements. I have to put a pump in mine, and I'm across the street. They built a retention pond across the street on property I previously owned when we sold, and you know the problem that Ken Brannon had with that. No one monitors it. Tommy's a great guy. He's going to put a retention pond in. It's not his responsibility after that. Who's going to take care of it? The city doesn't. It's not their responsibility. The water impact on this property is unbelievable. I get water coming up through my basement, and I've been there 43 years. I just filled in a driveway thinking that was my problem. No, it's not. It's the water in the ground. All right? So this many units, it's just going to be unbearable. And believe me, Ken Brannon, as you know, some of them know, was here complaining about his yard. All these other people on Merino Drive and stuff will be back, and they will be complaining. That's why I'm not against it. I'm against a monstrosity like you got down on Gulf Street, but you can put some units in there so the impact on the ground isn't so bad. Thank you.
Hi, my name is Susan Bedworth. I live at 72 Lindy Street. I have been here through all of the meetings and all of the things that we've been trying to fight this. I'm confused, and I wasn't really prepared because I didn't know what they were going to be proposing. But my understanding with 30-G, and I am against this, but they had to be similar units. They all had to be the same. You couldn't separate out the lower income versus the normal income. So how do you have 12 units that are going to be sold for as homes and then two duplexes that are going to be low income? I don't get that. I'm confused. I really am against the density. That's my house over there, and I'm going to get water, and I'm going to have the issues, and I'm going to have the traffic. I'm all for housing. I'm all for putting up what is supposed to be there. 3 houses, 4 houses, 5 houses, whatever he's supposed to have. I'm for it. And if he wants to take a single-family home and rent it for low $1,000, go for it. I mean, I'm okay for renting it below value, so someone who can afford it can go in there. But I don't understand 22 units on 2.5 acres. I'm confused, and I don't understand the 30-G. I thought they had to be similar units because you weren't supposed to be ostracized. So only the low income are going to have the rental units? So if somebody could explain all of this to me, I would greatly appreciate it. And I don't understand the retention pond either, because I know when we were here originally, the person that spoke said if the condo association didn't take care of the retention pond, the city would have to. But the city doesn't take care of privately owned property. So who do I call when they don't maintain the retention pond? I'd like to know that also. Thank you.
Anyone else opposed to the settlement?
Brian Anderson, 49 Ingersoll Road. I've stated my opposition to the development in the past. First of all, I wanted to thank those of you who made the decision in December 2013 to deny it. This particular project certainly has been one that has caused a great deal of angst gotten a lot of attention, and you have a very difficult decision to make. The one thing that I wanted to point out is that what's troubling to a number of residents is when there are developments that are being proposed that are 2 and 3 stories next to single-family houses. In this case, I realize that the applicant is proposing single-family and duplexes, but earlier in the winter, the applicant passed around a petition through the neighborhood to see who would sign for a 14-unit configuration. What we have in front of us is a 16-unit configuration. So I wondered how we went from the original 14 to now 16, and that's certainly a decision for you to make. If you're thinking about weighing the options, how is it that settlement includes more units than what was originally provided by the applicant last winter after your denial? Thank you.
My name is Paula Smith, 62 Hauser Street. So I've been walking around a lot of neighborhoods in Milford for the past few months, and without exception, this is the one issue that comes up time and time again. I encourage your board, even though maybe the chances aren't great of winning this, but we have to just stop. Please vote it down. We have to put a stake in the ground. We have to start looking out for Milford. There are ways of working with developers to make sure we put developments such as this in the right areas. Your board can help do that. The city can help do that. We have to put a stake in the ground. This doesn't make any sense with what's going on in Milford, whether it's Bick Drive, Wheeler's Woods, the 2 on New Haven Avenue, the Gulf Street property, Pond Point, and I'm sure there are going to be more coming. We have to stop. We just have to stop and let it go through the courts, and let's just keep fighting it. But you've got to start looking out for Milford, and we've got to start fighting for Milford. You hear what folks are saying, and we're hearing it on every application. Please start just protecting Milford and fight it. Just fight it. Please vote no on the application. Thank you.
My name is Jim McCarthy. I live at 119 Marino Drive. I've lived there since 1977. I agree totally with everything the people said today, and I'd just like to make a comment. If you look at Pond Point from Dawes or Buckingham all the way down to the end, it's all single-family houses. Now, I know they said maybe the zoning in there is for commercial, but there's no commercial building on Pond Point. So to have a zoning that allows this high density is inappropriate with the neighborhood. This neighborhood is all single-family homes. People have lived there for a long time. And the point is, everybody said, where does it stop? Today it's our neighborhood. Tomorrow it's going to be your neighborhood. We have to stop them somewhere. We have to try. Even if we lose, we have to try, because the character of Milford is not going to be the same. And Milford deserves to have a character that's friendly to the people who live there. Thank you.
Good evening. I'm George Koski. I live at 112 Marino Drive, and my neighbor right behind me lives across the street from me. We both feel the same way. The thing I don't understand, and maybe someone can explain, we had 3 really heavy attended meetings right here. It got to the point where someone thought something was going to happen to somebody, okay? This shows you how serious we are about this issue. And what happens? We are hopeful. We had evidence. The judge says he wants some kind of give back. 3 meetings we had. And in that 3 meetings, there was a lot of testimony. There was a lot of evidence that was there. We had video. We had personal opinions on everything. And what happened to that? We want to know. So please, the people behind me gave you the point. I'm going to reinforce that. Please stop this.
Good evening. Pam Staneski, 35 Point Lookout. And I, too, walk the neighborhoods, talk with these neighbors after this had come to your board and been denied, and thank you for that. But I guess my question in having conversations with several people this evening is they're not sure where this stands. It's in the courts. There is a appeal process, and now the judge is asking for feedback. But if I'm talking to these people out here, they haven't seen this new plan. And so my question to you is, has the process been followed with this new plan? This new plan has been submitted. Has it gone through inlands, wetlands? I know some things have changed, heights changed, dimensions of the buildings has changed, parking has changed. Has it gone to the police commission? Has it gone through the process that the original plan went through? Because these changes are significant to this plan, and I think that the community deserves to know that this plan is going through the same scrutiny as the first initial plan that was presented. My second concern is that what is this? We're going to give these public comment. Is this going back to the judge and he's going to make the decision? And that's just a rhetorical question. And also, I know that it was already mentioned, but the Board of Aldermen, in their wisdom, did, after several H-30G projects came through, give you the opportunity to hire your own experts. And if this plan hasn't gone through and been vetted, you now have that opportunity to hire experts that can make the case for why this should be denied when this goes back to that. So I just thank you for listening.
Anyone else opposed to the settlement? Okay. All right, for the record, everyone that's not an attorney or a contractor is against the application that's here. Mr. Burcham, what's next in this process? Meaning, what do we do now?
Take a vote.
And also, I guess just for the record, I have some questions. To make this settlement even more complicated, isn't it true that if the application that we filed to appeal the trial court's decision is denied, then the original application is just automatically granted?
Correct.
So it's a catch-22. We can't really take any more time because if the petition to appeal is denied, then we're out of options and it's automatically granted, the original application.
The matter is time sensitive in this context. Judge Berger made his decision sustaining the applicant's appeal of the 2013 board's decision. The city filed a petition for certification, which is in effect a request for permission of the appellate court to take our appeal of Judge Berger's decision. We do not know, we haven't heard from the appellate court whether they've granted that request. If they deny that request, there's nowhere else for us to go. And there's no ability to compromise or reach a settlement of a court case because the court case would be done. So therein lies the time sensitivity for this board that we ask a decision of you tonight, one way or the other.
And just another question. It seems like the judge blamed us for a lot of stuff, but did he ever reverse a decision? It seems like he had 24 in front of him and he approved all 24. Is that true?
Talking about Judge Berger?
Yes.
There's been 22 decisions, Matthew, 22 decisions that he has ruled in favor of the applicant, 2 of which petitions for certification were granted by the court. Those decisions were ultimately affirmed by the appellate court, but the appellate court did take them up on appeal.
So what I'm getting at, though, is it seems a little disingenuous for the judge to blame the board when he approves the application, but apparently he approves all these applications. I guess I'm just trying to protect the board's reputation here. I mean, he rubber stamps approvals on all these things, and then blames the board and then has the public come and speak out against you know, what has happened. So I just want to protect the board's integrity. But with that being said, any comment from the board? Mr. Quick.
We heard a couple of thoughts about changes in the plan. One is the ownership of maintenance of a retention pond, which I think is a legitimate question to ask. I also think that the scrutiny of the full planning and zoning process, this is a very different proposal. And I just think it's reasonable to give it that same thorough look. And as it is in somewhat a new set of drawings, a new proposal in a sense, that it should be looked at with a new eye, and something that we can now maybe, you know, capitalize on the aldermanic decision to allow us to hire a traffic expert and to take a fresh look at the whole thing.
I have two thoughts. One is, I mean, the burden is really impossible for the board. It seems like, and I've done research, the statute is written in a way where these things will ultimately get approved, whether at the board level or the court level. So I think everyone needs to be realistic. And it's unfortunate, and I think the change absolutely has to come from Hartford. With that being said, I'm against the settlement. I think, you know, there's a saying, choosing the lesser of two evils is still choosing evil, and while this application is not evil, it's still bad, so I'm against the settlement. I think we should just take our chances at the appellate court. If we're wrong about the law, let the appellate court tell us. If we're right about the law, then hopefully the right thing will happen and the application will ultimately be denied, so I'm against settlement. Ms. Servine.
I would be taking the opposite position, because I do feel like we're being asked to choose between two very difficult things. I'm not willing to gamble, personally, that you would end up with that project that you all were here so many hours for, and we were too, and listening to the very good reasons why you were opposed to it. I just am not willing to take the risk that that might be what you would end up with. This, as we know, was not a forum on H-30. The board and everybody has a lot to say about that, and that time has passed right now. We're also not looking at the merits of the original application. That time has passed. Right now, the question before us is, what do we think is best for the neighborhood, and what are the chances of hopefully the better decision being made? And I believe that the better decision is to go with the settlement myself, especially after what we've heard from Mr. Woods. And if we could stop this, we would, but we don't have the power. We would like to have the power to do it. We can't. We just can't stop. And I want to also add a word to the board. Board of Aldermen, we're very happy now that we can work with this new ordinance with the traffic study. So we know we have that now to work with, and we're very appreciative of that.
Hello?
Can I ask the board a question?
Sure.
Jerry Fiorentino. I live at 11 Spencer Street. And my question, it seems like what I'm hearing is that we can't fight this. But how does the city count affordable housing? Doesn't the city need to have a certain percentage of housing considered affordable? And apparently it is not meeting that quota. And why aren't they counting places like senior citizen housing? I own a 12-unit building in Woodmont. Every one of my rents is considered affordable. But because my property is not deeded affordable housing, the city doesn't count it. If the city were to do something to encourage people like me and bigger places like Robert Treat Park, apartments, to convert their places into affordable housing, would that end this issue? That's the question. Why can't we take this from a different approach like that?
I mean, theoretically, that's true. If more people deed restricted their low or their affordable housing, that would count towards the number, correct?
Yeah, but unfortunately, 830G specifies how we do the counting, and that's why we can't count that gentleman's housing. Again, it goes back to how the statute's written.
And again, I think it goes to my comment. It's really a self-defeating formula, and the statute's going to be here for a long time unless the language is changed, because we're never going to get to the 10%, and we're going to deny these applications, and they're just going to get overturned in the court system. So I think, you know, we have some representatives from Hartford here, and I think they need to change the law in Hartford, and we need to do what we can in Milford to change the way we count them, if allowed by state statute.
Right. It would make sense to push this off as far as we can to get that stuff done. That just seems logical to me. If we can hold off, fight back a little bit until we get some new legislature in there to count the places that really are affordable in Milford. I mean, because if I look at it a different way, just to throw this out there, I could maybe convert my place to affordable housing, and then I could put apartments where my parking lot is, because I wouldn't have to adhere to the zoning regulations.
Thank you.
So, you know, it's going to get worse. People are going to see opportunities here if nothing gets done, and it's just going to get worse for Milford. I live in Milford. I don't want to see these affordable housing things go in. The building I own is built in 1904, so don't blame me. But anyway, just let's do what we can to prevent it. Thank you.
Thank you. Any further questions or comments from the board?
John Callan, 35 Pauline Street. As I understand it, the court has said that you've got to give the developer license to do anything he wants, to disobey the zoning law. He did not, however, say that you had to change the zoning law. Suppose that we do not change the zoning law. The builder can go ahead and do anything he wants to do because he's got it, the judge saying he can. But on every deed, on every tax law, on every occupancy certification, cannot the Milford City stamp in large, with a large rubber stamp, not in compliance with the zoning, with Milford zoning laws? Probably, even when the current affordable housing law people become sensible and repeal it, the city could then go and demand that the property become compliant with the zoning laws. Now, would that ever happen? Probably not. But if you were buying one of these lots with a big not in compliance stamp on it, would you think twice before doing it, just in case you would be told later on, you got to tear that house down? Would any mortgage broker ever take the mortgage on a house that had that stamp on the deed? Just think about it.
Any more discussion from the board? Seeing none, would anyone like to make a motion? Mr. Quish.
I'd make a motion to deny.
Mr. Veen's asking for clarification. A motion to reject the settlement proposal.
That's correct.
Having a motion, do we have a second?
I'll second it.
Mr. Grant seconds. Any discussion on the motion? Mr. Sutton?
I just want to understand for myself and for perhaps members of the public and other members of the board, if Mr. Quish's motion to not accept the settlement proposal is defeated, does that automatically mean that we have approved the settlement agreement? Because we have not made an affirmative act to accept the proposed settlement.
Mr. Bertram or Wood?
Mr. Chair, through you to Mr. Sutton, the answer to your question is no. If Mr. Quish's motion fails, it doesn't mean that there would have to be a separate vote. A vote to approve has to state the reasons for the approval of the settlement in order for it to qualify for the court to consider it.
So we have a motion to reject the settlement. We have a second from Mr. Grant. Any discussion on the motion? Mr. Quish?
So, you know, I'm very conflicted about it because I think, like Mr. Veen, I see that potentially 2 years down the road, something will be built there. It'll be 16 units. If my motion fails and this board approves the compromise as presented, I am feeling and hearing from the neighbors that they would rather roll the dice. But I do want to just make them understand that the reality is that it's very likely that instead of 16 units, which is a less dense, and I don't know whether it's a better development in your minds or not, it sounds like not, because you all came out against it, and you knew there was a compromise on the table, that in all likelihood, we will go to court or not go to court, and either way lose, and you'll end up with the full original development as presented that was denied 2 years ago. But as an advocate for the neighbors and someone who feels deeply that 830G is being misused in almost every single case that I've seen, if you want to stick your heels in the sand, then I think that we should stick our heels in the sand with you.
Mr. Dolan?
Yeah, just to piggyback off of what Jim said, we're basically at the point where a decision is going to be made one way or the other. As far as I'm concerned, you guys in the audience should have the most say about it, so I'm inclined to go whichever way you guys want, but I just want to make sure that am I right that you guys, and show of hands is fine, am I right that you guys want to roll the dice and with the knowledge in mind that it might be 32 units that you're getting as opposed to accepting a settlement of 16. Am I right about that? 23 rather. 23 versus 16, you guys want to roll the dice? Does anybody not want to roll the dice? Okay.
And I'm also against the settlement, and staff, correct me if I'm wrong, but while the settlement offer has less units, does it shift the burden to the city to take care of the road and plow the road? So not only will the residents be getting something they don't want, they'll also be paying a lot more for it than if we just reject the settlement.
The original application would have the roads and the drainage, all of that would be taken care of by the applicant. The compromise or the proposed settlement would create a city street that we'd be responsible for, as well as a drainage basin that would be on private property that we would probably end up responsible for.
So for that reason, I'm against the proposed settlement. Any further comment? Mr. Mute.
Thank you, Mr. Chairman. Looking at both plans, the second one is less dense in the amount of buildings, and also there's less pervious area, because in the original one there's more, it's more of a parking lot where none of the apartments had their own garages or driveways. Now with the second plan, it's all off-street parking, there's less pavement, so which is going to have less runoff, where the people on the side streets are worrying about the flooding. And all the homes are further away from the property lines, and there's going to be more green space in between the new proposed homes and the first ones where the apartments at some points are only 12 and a half feet from Mr. Lawless's property line. So this way, with more green space between the homes and the property lines and the people's homes, I believe that there'll be better drainage once this property is developed and storm drains are put in there with the retention pond.
Ms. Servine.
I back up Mr. Mead in his assessment. That's one of the reasons why I think it's wise to go with this so-called compromise. I also don't think it's wise, from my point of view only, that we use this as a form on H-30. There are better ways of doing it than to use this application or this piece of land to do that. And I will stick to my guns. I may be the bad guy on this board in doing this, but I do think that the chances are much better. You're going to get a better project if we take this settlement as it is, rather than end up with the first application 1 or 2 years down the road.
Any further discussion? Seeing none, we have a motion, we have a second. All in favor of the motion? Okay. 6 in favor, all against? Motion passes 6-4. We will take a 5-minute recess. If everyone could please be seated, we're going to continue with the agenda. Hi. The next item on the agenda is 1613 New Haven Avenue, Zone R-12.5, petition of Thomas B. Lynch, 830G application.
Well set. Right. Good evening, Mr. Chairman, members of the board. For the record, my name is Thomas Lynch. I'm an attorney with the law firm of Lynch, Trimmicky, and Boynton, and my office is located here in Milford at 63 Cherry Street. And I'm here tonight with my client, Charlie Gagliardi, who's seated in the front row here. Mr. Gagliardi is the owner of the property located at 1613 New Haven Avenue. And we're before you tonight with an application for approval under the terms and provisions of Section 830G of our Connecticut General Statutes, more affectionately called the Affordable Housing Act, for the construction of an 8-unit multifamily residential development on this property, which my client purchased some 2.5 years ago. I also have with me tonight my good friends John Wicko from Milford. The board is well familiar with John and the many projects that he's presented to you over the years, as well as Ron Wasmer from Connecticut Civil Group, the site engineer who is going to go through the elements of the site plan. And also, lastly, David Spear. David has appeared with me numerous times before this board offering expert testimony. He has a traffic study that he has prepared and will present to you to indicate that in accordance with the provisions of the statute, there will be no negative impact relative to public health and safety from the traffic that would emanate from this project. So just by way of a little bit of background, as I mentioned, the property is located in the R-12.5 zone in Woodmont. We're all well familiar with New Haven Avenue and the way that It stretches from downtown Milford. The CDD4 zone extends from the center of Milford out to approximately the intersection of New Haven Avenue and Merwin Avenue. And there's a variety of uses along that stretch. There's large multifamily complexes such as Colonial Manor. There's single-family residences. There's the commercial developments along the intersection of Pond Point Avenue and New Haven Avenue. And then lastly, before New Haven Avenue traverses into Woodmont, there's the large commercial section at the intersection of New Haven Avenue and Merwin. But as you travel east on New Haven Avenue, the area tends to take on more of a residential character. And this project is designed to blend in with the existing residential character of the area, as well as some 6 or 7 multifamily complexes that are located in Woodmont. We're well familiar with the Woodmont condominiums, the Anchor condominiums, the former Seaview nursing home that was developed on Hawley Avenue into condominiums over the years. So contained within the context and the confines of Woodmont, there are other multifamily complexes that have been developed over the years. Most specifically, the board is familiar with the property at 1556 New Haven Avenue. It was the subject of an application that was brought before you in 2013 by Bella Properties. And I won't go into great detail. You've all lived through that through the public hearings. I assume that there's some of the neighbors that are here tonight that attended the public hearings for the application for 1556 New Haven Avenue. But the sum and substance of that property is that a 7-unit multifamily development in accordance with 830G was ultimately approved this past year by the board as part of a settlement of a prior denial that was brought to the land use court. And you all know the terms of that settlement, and that's across the street from my client's property, about some 700 or 800 feet to the west on the other side of the intersection of Anderson Avenue and New Haven Avenue. The project is going to consist of 3 buildings. There's going to be a total of 8 units. There will be 3 units in buildings 1 and 3. The 3 units in building number 1 will be designated as the affordable units under the affordability plan, which I'm going to touch base on with you as part of my exhibit that I did hand out to you. This property was also the subject of an application that I presented to this board back in 2013. If you recall, in June of 2013, I represented Mr. Gagliardi with an application to subdivide the property to 2 lots to have single-family residences built on the 2 lots. The property consists of some 18,600 square feet, and it's located in the R12-5 zone. And my argument at that time was that because of the proximity of other zones close to this, i.e. across the street and directly diagonal from the property, there was the existence of other residences constructed in the R75 zone and the R5 zone. And I used the I actually went back to the minutes. I used the term that this property was an anomaly in the sense that the other houses across the street were on much smaller lots than what the R12-5 zone calls for. The handout that I gave to you at the outset, page 1 and 2, consists of the application for the subdivision that we submitted at that time, and page 2 was David's letter to the board recommending a denial of our application for a 2-lot subdivision. And quite frankly, I was seeking a waiver of the lot requirement in that zone as well as frontage waivers. And the board ultimately denied that application, but my client then sought the ability to bring this application to you tonight under Section 830G to develop 8 residential units. And the statute, as we all know, encourages development of affordable housing in the community. If the need for the affordable housing is something that's present, we've argued on the other applications that we've made to you that that is a concern here in Milford, and that's why we've brought this application to you tonight. We also have to address public health and safety issues, of course, and David is going to touch base on the traffic issue. But part 3 of our handout to you tonight goes into the required affordability plan, or the compliance plan that's required under the statute. This is a document that I've prepared for you on other applications. I'm not going to go into great detail with it, but what I am going to do is just highlight the fact that we do propose 3 units of affordable housing on this project. The statute requires a minimum of 30% of the project be set aside for those individuals earning either 80% of the area median income or 60% of the area median income. And again, as we've seen in other projects that we've presented to you, because Milford's per capita income is so high that an individual that would qualify, or a family that would qualify for a 2-bedroom rental unit in this project would have an income at the 80% level of some $62,208, and a family qualifying for the 1 unit that would be designated set aside for those earning 60% of the area median would mean that those individuals would have a income not to exceed $48,000. So clearly, this isn't low-income housing. You know the argument I've made to you on all the other projects. I have to make it again as part of the record to preserve it for the record. But clearly, these are units that are going to be designated for individuals that are earning a sufficient income to meet the rental that's shown on here. For the individuals earning 80% of the median, the rental would be calculated at $1,398 a month, hardly low income. And those earning at the 60% level, the rental would be $1,066. Again, affordable, not low income. The other pages that I've tagged for you basically go through the department approvals that came in, or the department comments that came in during the process of submitting these plans to the various city departments. We originally had sent the plans to the police commission, and the police commission last spring had issued a recommendation for denial. And the reason that Lieutenant Dumas had made, or the rationale that he had made in his recommendation at that point, was that there was adequate parking on site, the turning radiuses were adequate, but he was raising a concern as to whether or not the garbage trucks could come in off of New Haven Avenue, make the pickups, and sufficiently maneuver around the site. The plans were reworked. The department had also recommended some additional visitor parking spaces. Ron and John sat down and reworked the plans. The plans as presented to you tonight added 3 additional visitor spaces and a handicap space, and the turning radiuses for the fire trucks and other trucks meet the standards that the fire department requires, which again I'll touch base on in a second. But basically the plans were re-reviewed by the police department. I've included in our handout for you the memorandum that was submitted by Lieutenant Roji. That was then passed on to the police commission, and at their September 15th meeting this year, the police commission voted to approve these plans as presented. I've also included, after his final statement, I've included in this report pictures. Again, David is going to touch base on this, but pictures showing the sight lines up and down New Haven Avenue from this property, and the pictures speak for themselves. The sight lines along this stretch of New Haven Avenue, there's probably a quarter or half a mile of straightaway on either side of this site, both extending westward back into the city and eastward towards the Oyster River and the boundary with New Haven with West Haven. So clearly the sight lines are excellent on this site, and the police department has concluded that this poses no public safety issue. The other concern that had been raised in Lieutenant Vaughn's original report was addressed in a letter that we received, and I submitted it to the file last week. It's a letter from Peter Giordano of All American Waste, who is the refuse company that my client will contract to handle the removal of the trash and the refuse and the recycling on this property. And his letter indicates that a pickup truck rather than a dump truck will be utilized because of the small size of this project. A pickup truck to pick up the garbage will be sufficient. So again, that addressed the last issue that Lieutenant Dumas had raised in his initial report. Plans also were approved by Chris Saley. They were passed on and reviewed by the city engineer. There were comments that the city engineer, or the prior city engineer, had made, and Ron incorporated them in his revised plans, and he'll touch base on that when he goes through the site plan. Very important, again, in the area of public health and safety is the review by the fire department. We've included the report that was submitted on August 28th, signed off by Fire Marshal Baker, saying that the plans have been approved by the fire department. If you look at the site plan, there's the 28 and 29-foot access way provided for fire trucks to come onto the site, and there was a recommendation that the buildings be sprinkled. They will be. So that is a condition of approval. They've been incorporated in the plans, and John will touch base on that when he goes through the elements of the buildings themselves. So the last item was the approval from the Sewer Commission. There had been concern based upon the gallonage count, based on the calculations that the Sewer Commission traditionally uses in meeting standards for development on properties. They use a density based on the zoning density. I appeared before the Sewer Commission. There's a recent Supreme Court case that I'm not going to get into great detail about, but I made the argument to the Sewer Commission that this project meets the standards of the fact that the sewer capacity of the city of Milford can accommodate this project, and accordingly the Sewer Commission at its meeting on May 27th made a conditional approval. There are improvements that are being made to the Rock Street pump station, and both Mr. Macaluso and Mr. Saley had made the representations to the commission that those renovations should be completed within the next year, and this approval is conditional upon the city's renovations to those two pump stations being completed prior to this property being hooked up to the system. So that touches basically, Mr. Chairman, on the comments I wanted to make at the outset. We had originally designed a project with 9 units. John and Ron can show you the sheet that they had compiled. I think John brought it with him tonight. But to address some of the concerns that the Police Commission had made, to address perhaps trying to act in the spirit of keeping with the settlement on the Bella property application across the street, we actually reduced the number of units on this project from 9 to 8. So I want to make the representation to you. The site could have accommodated 9 units. We scaled it back to add green areas between the parking to accommodate a wider turning base for the fire trucks, and some setbacks in the back. I know that David had made some comments in his staff review about the rear setbacks and some landscaping. John, we received this, with all due respect, we received that this afternoon, but John endeavored to sit down and put together some additional landscaping to be able to present to you tonight to address David's concerns. So with that, I'm going to turn things over to John Wicko to go through these buildings that he planned and designed for you. He's got elevations, and then we'll turn things over to the other 2 presenters.
Good evening, John Wicko, office at 50 Broad Street. My charge was to design some buildings to fit on the site. I'm just going to take a walk over here if it's all right. My leash. As the application says, 8 units, each having 1,139 square feet. I have a whole stack of the drawings behind here, which I'll just kind of refer to one of the buildings because they're typical layouts. Each consists of, on the top floor, the 2 bedrooms and 1 bathroom, with a half bath on the living level, with a kitchen, open living dining arrangement. And at the entry level is the garage, which is a tandem 2-car that also houses the laundry facility and mechanical spaces. 3 buildings. Building 1 is a 3-unit, 3,417 square feet. Building 2 is a 2-unit, 2,278 square feet. And building 3 is the same as 1, 3,417. I did draw the front building, which is the New Haven Avenue Street elevation, in its colors that we called out, and with some embellishment, which is a further implementation of some foundation plantings, basically, which I can go into later. But there's going to be much more landscaping involved, kind of close to the buildings. This front building represents a residential quality to it. 3 units. It has 2 porticos of a scale that matches just a lower level that I've designed, that has a porch-like roof on it, and a base rendered in a wider siding, a horizontal clapboard with a different color. So there's some architectural interest within the building of this type. All the buildings will meet the fire and building code for safety, construction type, distances between building to building. So they're pretty typical buildings. They're common buildings. We do them all the time. And they're configured in a townhouse configuration, which is really a single family house that everyone has their own stair. They have their own identity. So there's a fire separation between unit to unit, which allows, if there is a fire, which is highly unlikely because the buildings will be sprinklered, and that's been proven to just douse any fire that may occur, because the buildings are each contained, so the likelihood of a spread of a fire is minimal. In speaking to the bulk and height of the buildings, the drawings will depict that the larger units, which are the 3 building units, are 36 by 48 in its footprint, which is the garage level. I'd step back the second floor and the upper floors to 34 by 48. And then the smaller 2-unit building measures 36 by 32 and 34 by 32 with the same spreads in the different floors. The building height meets the residential requirements, which we're under, with 32 feet from grade to the midpoint of the roof, which results in a 9-foot ceiling at the first living level and an 8-foot ceiling at the second floor bedrooms, and we're using a 7'7" entry level height. As Tom talked about, we did have a 6-unit building which was never presented. If you care to see it, I do have it as it was presented back before we finalized with the lower number of units. The 6-unit building was the rear building, which was a long kind of prominent feature, which really kind of blocked a lot of the light and air. So we decided to incorporate the 2- and 3-unit building back there to help the site and the appearance of the project. As mentioned, there is in David's report, there is some talk about the. I don't have my glasses, so excuse me for trying to squint and take some time doing that. Oh, just wanted to make a few comments on the first item, number 1, with the 5- and 10-yard setback. With the landscaping, there's one element, retaining wall, on either side for the turnaround for the kick out. Those are at one point within 5 feet. They are, landscape elements. There's not a building, just to be clear. The buildings do meet the side yard requirements and the front yard requirements, with the exception of the rear, which is less than the required. And there is landscaping in those areas too. Really, the biggest thing that I could add to this list is I spoke with the property owner about the landscaping, and what was presented in the application was the basic minimum of the landscaping with trees and lawn and kind of normal, if you will, landscape level. There is an opportunity which I think which I could present in the future, but I have rendered, as I said in the front elevation, that where we can, we will be putting kind of typical foundation plantings that you'd see in a single-family house. So it'd be more in keeping with some of the neighbors that are kind of dispersed through the area, with different types of shrubs and small trees and some evergreens. Nothing's been drawn up at this time, but that's the intention of that landscaping plan, is to kind of fill in some of the green areas that were on that, to incorporate some more foundation plantings. They're pretty basic buildings. They fit the site pretty well, and I can answer any questions now, or if you want to wait till later for that. I can turn this over to Ron if you don't. If you do, then I would certainly be willing to answer those.
Thank you. Good evening. For the record, Ronald Wasmer, professional engineer, land surveyor with an office at 158 Research Drive, Milford, Connecticut, here representing Charlie Gagliardi and Seaview Cove LLC. I did the site plans for this project. We did at one point, in the very beginning, consider a 6-unit building in the back with the 3 units in the front, and I brought a sketch to that. Early on, the applicant looked at that and decided to scale it back to what we have now. I'll briefly walk through the plans that I prepared. Before you is the site plan. You see New Haven Avenue. This indicates the building dimensions, various setbacks, parking spaces. You see we have 2 parking spaces in the garage for each unit and a parking space in the front. We've also added 3 visitor spaces. One of them will be handicapped. The driveway is 28 feet wide. Entering from New Haven Avenue, we have some traffic control devices, stop sign, stop bar. And whatnot. Again, on the site plan, we show the various adjoining buildings, and you can see that there are several buildings on New Haven Avenue that are approximately the same distance from our site, from the street as ours. as well as properties in the rear which have buildings that are virtually on the property line. So in some instances, our buildings are much further away than the neighboring properties. We have a grading and drainage plan. All the drainage will be stored on site. This is a very well-drained gravel soil. We have on-site storm galley systems and catch basins. All the roof drainage and parking lot drainage will be directed to those on-site storm drainage features. We have a utility plan. The utility plan incorporates also details on storm drainage, sanitary sewer. It's served by sanitary sewer and public water, and underground electric and cable telephone. Erosion control plan is simply just to demonstrate the features required during construction to prevent any erosion off of the site or sedimentation. The next couple of plans are the building plans. This is one of the complete zoning packages. So I'm going to skip through those because John just discussed those. We do have a landscaping plan. I know that John just made reference to some additional plantings that were going to be added, but this highlights the areas, the green spaces will be the landscaped areas. We have some shrubs here along the property lines. This will help screen the properties from the adjoining screen the neighbors from this project. We have a couple street trees proposed, and in the areas of the visitor parking, we've proposed grass pavers. There's a couple mature trees that will remain, and then there's a couple mature trees that need to be removed. We have a lighting plan. There's just going to be one pole light located right here central to the rear parking areas, and you can see there's no light trespass off of this property onto the adjoining properties. It's a 14-foot pole light with the then we have some miscellaneous details just for the various utility and civil items that are going to be installed, as well as some indications for erosion control, curbing, tree protection. We have a water quality chamber for storm runoff. And last is just an existing condition survey. There was a single-family house on this, which was in terrible condition. It was knocked down several years ago. I'll be happy to answer any questions now or at the end of the presentation. Thank you.
Thank you. We'll wait till the end of the presentation for comments.
Good evening. For the record, my name is David Spear, the principal engineer with DLS Traffic Engineering in Windsor, Connecticut. I'm a registered professional engineer, and we were asked to look at this application from a traffic engineering point of view. The proposal is for 8 townhouse units at the site at New Haven Avenue at 1613. Our study included observations of area traffic operations and characteristics. We reviewed the Connecticut Department of Transportation accident data. We collected manual turning movement counts. At study intersections, we projected background volumes. We estimated site-generated traffic and distributed that traffic to the area roads. And we projected combined volumes and completed capacity analysis calculations. Just for a little background, the existing conditions New Haven Avenue is the state road. It's Route 162. In the vicinity of the site, it's 30 feet wide with 12-foot lane and 3-foot shoulders provided in each direction. The speed limit posted is 30 miles per hour. Southwest of the site, Anderson Avenue intersects New Haven Avenue to form a signalized intersection. The northwest Anderson Avenue approach is one-way northwestbound, and the signal operates in 2 phases. We completed turning movement counts, AM and PM peak period turning movement counts at the intersection of Anderson Avenue and New Haven Avenue, and the intersection of the Site Drive and Grove Street. The New Haven Avenue volume showed AM peak hour traffic of 466 vehicles per hour, and the PM peak hour traffic of 635 vehicles per hour. The Anderson Avenue traffic showed 237 trips or vehicles in the morning peak hour and 262 in the afternoon peak hour. The Grove Street traffic was very nominal. It's a dead-end street, and the volumes were negligible. The accident history was taken for the latest 3 years on New Haven Avenue between Anderson Avenue and Rosemary Court. In that location, there were a total of 7 accidents during the study period that included 3 rear-end accidents, 1 turning accident, 1 angle, 1 pedestrian, and 1 fixed object. These accidents were caused by following too closely, violating traffic control, failure to grant the right-of-way, an unsafe right turn movement, and an improper turning maneuver. All of these accidents were caused by driver error and are not related to the geometry or the existing operations of the state road. The accident experience will not be impacted by the proposed development. The proposed use is a very small generator and will not have a significant impact on accident history. The other thing related to accidents, which was also discussed earlier by Attorney Lynch, is the site distance. The site distance looking left and right from the site drive is over 500 feet in each direction, and based on prior discussion and pictures, it's well over 500 feet, but we rounded it to 500 feet. For 30 miles per hour, you need a sight distance of 335 feet according to DOT guidelines. For 40 miles per hour, you need 445 feet of sight distance according to DOT guidelines. And so in this case, we have enough sight distance for the posted speed limit plus an additional 10 miles per hour to 40 miles per hour. And in fact, we have more sight distance than that, which would be above 40 miles an hour. The trip generation was based on the Institute of Transportation Engineers Trip Generation Manual for residential condominium/townhouse units. And based on that data with using the trip generation equations, we estimate that there would be 7 AM trips. That's 1 entering trip and 6 exiting trips, and 8 PM peak hour trips. That's 5 entering and 3 exiting. So as you can see, it's a very small traffic generator. That traffic was distributed to New Haven Avenue based on the existing travel patterns and added to the background traffic to get the combined volumes for analysis. The capacity analysis was completed for the 2 study intersections for New Haven Avenue at Anderson Avenue, which is a signalized intersection. That analysis shows level of service A for the morning peak hour and level of service B for the afternoon peak hour. The Site Drive intersection showed level of service B or better for all the analyzed movements. So in conclusion, this is a very good location from a traffic engineering point of view. It has excellent access. There's no accident trends that would be impacted by the proposed development. The intersection site distance is very good, allowing safe access in and out of the site. The levels of service at the study intersections are level service B or better. And the signal queues, we also looked at the queues from Anderson Avenue coming back towards the site to see that the queues would not impact the site drive, we found that the queues are going to be shorter than the distance from Anderson Avenue to the site drive, so there's no interaction between the signal queues and the site drive intersection. So that concludes my traffic study. Turn it back to Attorney Lynch.
Mr. Chairman, just to conclude our presentation to you, referencing back to the memo that we received today from David, items number 3 and 4, I don't think we addressed. He made mention in his memo that there were patios constructed using grass pavers. The plan elevations show no doors to the grass paver area, so the applicant should explain this. Well, very simply, the patios were added on later. What's shown there now are windows, so doors will be supplied there to access the patios. And then lastly, item number 4, a lighting plan was submitted showing compliance with our regulations, although it is not clear whether or not the patios have lighting. The patios will have lighting. They'll have a regular exterior residential light outside of those rear doors that I just mentioned that would be added. But with that, that concludes our presentation to you. We think that we've supplied you with evidence showing that this property will be developed in a manner that does not impact public health and safety, in a manner that exceeds or offsets the need for affordable housing in the community. That's what the statute calls for. The traffic to be generated here will be minimal. This is a state highway. I remind you, this is Route 162. It's a state highway, well-developed, maintained by the state. It's a wide road with shoulders, with extensive straightaway in either direction, as both I and David had mentioned to you, with excellent sight lines. We have also addressed all the concerns of the fire department, the 2 major public health and safety departments here in the city. So we submit to you that this is an appropriate application for you to approve. Thank you.
Thank you. Any comments from staff?
No, Mr. Lynch answered my questions.
Any questions from the board? Ms. Servine.
A couple clarifications. Mr. Lynch or Mr. Wicko, whichever one, I guess. At first sight, who do I want to speak to? Mr. Wicko, Mr. Lynch? I want to talk about the parking spaces. I think these tandem spots are, at first sight, they look good, but when you think about it, they seem somewhat problematic for the people who are using those parking spaces. A lot of backing out, replacing this and that, and as I see it, at least one of those parking spaces underneath would be used as storage, not for parking, so it's sort of...
You must remember that these are single-family houses, so it's not any different than 80% of the houses in Milford where the single driveway to the single car. It is in character with the size of the house that they are provided. We all get along, with it, with moving, getting the right. It's kind of like taking a shower in the morning. You got to make sure you get the right sequence, and then you're good to go. They are there. They're provided. It's good if a family only has one car, or if it's a single. Right, and it also, as Attorney Lynch said, on the shoreline area, most of the houses, if not all of them, with the elevated, the same type of arrangement where they're parking under, which is, provides more than adequate, and it helps the area. But there are also visitor spaces that were added where needed.
Can I go ahead then and talk about those visitor spaces? I think they're on the grassy pavers. If
That's
I'm
correct.
I'm wondering about those grassy pavers. Now, are they meant to grass over or to stay as pavers, or?
The intention, I believe, and maybe Ron can clarify it if I am not speaking properly, that the intention is that on the occasion that they're needed, because frankly, the site meets the parking requirements without the visitor parking area. So it's been proven that, you know, the two work. But those are intention to be, you know, holiday or in the summer where they're not used all the time, and that we don't anticipate them being used all the time. So the grass would grow, and then it'll, you know, just like you're parking on the lawn in your own single-family house, you do it every so often so it doesn't hurt. But these are actually designed to carry the weight of a car, so it doesn't mat down the soil.
Isn't that as much as weeds and the grassy pavers and how that area is cared for? At first sight, I thought, oh great, it's permeable. You know, so we like that. We always like permeability, but it also means a lot of weeds and weed killer possibly. So that would certainly cancel out the advantage of permeability. But who will be caring for those areas?
Well, that I don't know. I presume there's going to be a maintenance service that would take care of that, professionals who know how to deal with those conditions, but I'm not exactly sure. Maybe if you need it now, we can try to figure it out, but we can get back to you on who's going to do that.
These are the grass pavers that you're familiar with. They're hollow, kind of honeycomb structures, so there's soil in between. Yes, they're permeable. Yes, the grass will grow in between them. Any grass cutting will be done by a maintenance company.
Okay, thank you.
Yep.
Any questions from the board? Mr. Nickel.
Yeah, can someone address the snow removal aspect of this project and where the snow is going?
As we were sitting down, I said to John, I think Tom Nickel may want to know about the snow, so let's be prepared to answer that question. So as you come in from New Haven Avenue, there's two areas to the right and to the left that are sort of appendages from the parking area. So it's anticipated that those are two areas that could accommodate that. Along the driveway entrance as well, there's a small, narrow area to the west, so that could accommodate it on that. And then similarly on the easterly side, on the other side of the driveway as you come in off to the left. So those would be two areas that would be used as snow shelves.
Any further questions from the board? Mr. Nickel.
Yes, on this project, who is the property manager?
That hasn't been determined yet, but my client would probably use a professional property management company in the area, or he could do it himself. Right? Yeah. Do you have a name? Right. He'd probably be putting that out to bid.
Anything else from the board? We will now open this up to public comment. If you could please follow the following procedures. Approach the podium, clearly state your name and address, and please spell your name for the record. Address all comments to the commission. If your comments have been previously presented, please refrain from repeating. You could simply say you agree with something that was said before you. State your comments clearly and succinctly, and please try to keep your comments under 3 minutes so we could get everyone in tonight. If you are in favor of the application, please approach the podium. Seeing no one, if you are against the application, please approach the podium.
Good evening. My name is Wendy Fitzgerald, Fitzgerald. I live at 12 Anderson Avenue. That is the property that is directly adjacent to the New Haven Avenue property that we're talking about. And just to give you brief history, the property that we're talking about was part of my property initially. It was the Vacca's property. I have the 6,000 square foot mansion on the corner of Anderson Avenue and New Haven Avenue. The house that these people tore down was the carriage house to the initial mansion. I also want to go on record that it's a historical property. It was built in the 1800s, and it's in the book of Woodmont, pages 11 to 13. So because this nice gentleman purchased the lot and tore it down, and it didn't get approved to put on a single-family residence, 2 single-family, he's tried to put little mini mansions on, and because he got denied, now we get affordable housing. So I get to pay $27,000 a year in taxes, and the property, my property, I have an in-ground pool, and yes, we have a nice little beach, and now my pool is going to be blocked by this property. I also want to note that the traffic study is totally wrong, because I have 2 entrances to my property. I have a full acre. It's Anderson Avenue and New Haven Avenue. And actually, on the New Haven Avenue, the entrance that they're going to use, there's 2 bulkheads, stones. It's an old driveway. Before my children were born, I had the opportunity of entering from New Haven Avenue or Anderson Avenue, and it was a death trap. In the morning, I couldn't even get out, and I was in banking for 30 years. There's no way 8 different families are going to be able, rush hour or coming home, that's not going to impact that. It will be a nightmare. Trust me, that study is wrong. I can just take my camera. I look at it every day. Another thing that I also wanted to bring up, the property that we're looking at, I find it interesting you show the first property, but the other 2 properties, I'd love to see where that's going to be adjacent and how it's going to impact my property. I don't understand where it's going to go. And I believe the gentleman said it's not done because it still shows the 6th family one in the back? Well, answer me.
They'll have an opportunity to answer your questions.
I'm sorry, I don't know how that works. Okay, I'm sorry. I would like to see exactly how the 8 units are going to fit. You know, I have a son here where I moved to Milford for their schools. I moved to Woodmont for the area. I paid more money than other people because I could, and I wanted a better life for my children. And now this beautiful property, this historical property that I own, I'm proud to own, that's in the Woodmont historical book, it's going to be all wrong because somebody came in and they were able to buy a piece of land that couldn't get approved, and now we're just going to throw up affordable housing that I'm going to look at. And I'm all for affordable housing, absolutely. But the lot had a single-family house on it, not 8 units. And I'm just dead against it. Thank you.
Anyone else opposed to the application?
Mr. Chairman, my name is William Stark. I live at 17 Chaucer Court. If I may, I have a question. I thought I was here this evening for a public hearing regarding the approval to construct 8 residential units of affordable housing. And now it's 3. This may be a wording issue, but it seems to me that the legal notice said 8 residential units of affordable housing.
Mr. Sulkus, any problem with the legal notice?
We would have to get back to you on that. I'd have to get back to you on that.
It's the same, says the same thing on the agenda as well. And I know what the answer is. I just wanted to bring this up. I mean, it's only a municipal government legal notice, so I guess it's not critical. I was about to commend Mr. Gagliardi for designating all 8 units as affordable. But I guess I can save the first paragraph of my statement. To the best of my knowledge, the freeholders of the borough of Woodmont are opposed to this and other recent special permits, not because we're opposed to the concept of affordable housing, but because the statute allows the developer to circumvent the municipal planning and zoning regulations, and notably those regulations that govern required setbacks. For the most part, Woodmont is a neighborhood of single-family detached homes on reasonably sized lots. In some cases, this type of overdevelopment would allow for 3.5 stories of structure to loom over one's backyard fence. I'm opposed to this type of development because of its negative impact upon the character of our neighborhood and a diminished sense of personal privacy. While I do not see any obvious public health and safety issues that might prevent this permit from being approved, I do have to express my opposition to approval based on the aforementioned factors. In addition, no one seems to take into account how this type of development might affect the value of surrounding properties. It is an egregious action on the part of the state to force a lessening of one person's assets in order to provide for a developer's increase in assets. The city assessor should consider this and provide a property tax rebate for all abutting properties. Thank you.
Hello, my name is Chris Pooler. I live at 2 Grove Street, which is directly across the street from New Haven Avenue from this property. And again, it's from not keeping in the character of the neighborhood. Again, we're not against the affordable housing, but it's just developers are just using this law to circumvent a way to get their buildings in there. And as it's been stated, his original intentions were denied. So now what choice does he have? Well, we'll go in with affordable housing. The other thing that I have a concern of about these grass pavers that were brought up, the property is probably less than 200 feet from the beach, Long Island Sound, and beach beyond that. If cars parking on these pavers, the fluids, the salt, the chemicals at the winter time, everything's going to drain off of that. Where's that going to? It's going to go into the groundwater, which is going to drain into the sound. And then another item that was brought up was patios. And it looks like one unit is going to face directly to New Haven Avenue. Being affordable housing, I assume we're going to want families in there. They're going to have kids. Is there going to be a barrier from the front door to New Haven Avenue, especially if there's a patio area there? Is there going to be fencing to contain children? There's really no yard area that's visible in these drawings either, so it just seems way too dense for the neighborhood, and especially it's supposed to enhance the lives of people that need affordable housing. It's too dense. Thank you.
Tina Andrianovich, A-N-D-R-A-N-O-V as in Victor, I-C-H, 1564 New Haven Avenue. Haven't seen me in a while. I'm back. So, I do warn all these gentlemen here, I would distance myself from the I don't even want to remember the address, 1556 New Haven Avenue project. Please don't jump on their bandwagon, okay? Because what's going on there that you guys approved, all about how, oh, well, we took a settlement, so everyone should be happy and feel warm and cozy about that, of 1 unit less, like you guys did, 1 unit less. That's good for you. Let me pat you on the back. There was only 1 unit there to begin with. It was a false application that said it was a 2-family house. It was a 1-family house. You settled and said, okay, I'll keep it as a 1-family house. You know, it was just smoke and mirrors, and they won. Anyway, so I would hold off on that stuff. I wouldn't be going on that. A couple things on this application. Seems like we're really rushing through, aren't we? All right, we're talking about sewer plans. Is that into our new pumping station that took forever to build? Neighbors opposing it. It's finally in place because Woodmont needed help we needed that pumping station. And now we're going to overburden it. Yay! Good job. Hope you're ready to build another one. Maybe you could build that next to me too. Whatever. Okay, and you're saying that this is all sour grapes because you couldn't build 2 units, so now you're going to build 8? Wow. I hope you picked up your jacks when you left the playground. Okay, I'm sad about this, that this is happening all over Milford. It's happening on my right arm. It's happening on my left arm now. I live on New Haven Avenue. I live right by the corner of Anderson Avenue, New Haven Avenue. I need to know, when were those traffic strips out that you were counting all these turns? I turn there twice a day, never saw a single one. So I need to know where all these statistics are coming from, and everyone's, you know, doing all these great studies. I didn't see them, all right? I don't know where they are. I wasn't even going to talk tonight, and I'm sorry if I'm a little everywhere, but this is for the board. 1556 New Haven Avenue, you approved, settled, all this other good stuff. Guess what? It went up for sale because all you did was give this developer a bargaining chip. He's going to flip that property and sell it to somebody else. And I just ask you, are we going to start all over again? Is that somebody else going to have to do diagrams and get studies and all that? Or are you just going to let him go through too? Because that's where 830G is going now. If you thought it was bad just pushing in overdevelopment, now we're flipping Milford. And nobody really seems to care. So, you know, I know what your position is. You can't vote against it and all this other stuff. But someplace this has to stop. And I don't know where, but this appears to be somebody who slapped together a plan and said, let's rush it through before they change the law. I guess 2 years since I've been here for the Pond Point meetings, they haven't changed the law yet. I guess they have more time, but please look carefully at this and don't give me another headache. Thank you.
Hello, my name is Steve Hayden, Hayden. I live at 1592 New Haven Avenue, right on the corner of Anderson Avenue. My wife and I, Deborah, we just moved to Milford about 1.5 years ago. I grew up in Milford, and we moved back here 1.5 years ago, and we love living in Woodmont. But I'm here to speak in opposition to this project here. First of all, I don't know if any of you are familiar with the lot itself and have driven by, but if you had, you have to wonder how they're going to fit all this stuff in. And it just doesn't look like it fits for what the property is there. As far as the traffic situation goes, as that woman said before, she didn't see the the counters and the thing, and I've been living there since July of 2014, and I don't remember seeing anything like that in the roadway either, counting it. But as you know, that area there is highly congested. It's the main thoroughfare from West Haven along the shore into Milford, and the exiting way from Milford into West Haven. And it's compounded in the summertime when there's hundreds of motorcycles that drive up and down there every single day. I would dispute the number of ticks he claims that he saw or got on his machine for the amount of traffic that is there. It's extremely busy all the time. I work out of my house when I'm not on the road, and I'm firsthand to seeing what the traffic situation is there too. As far as the ownership of the property there is, I don't know the owner of the property. I don't know where he lives, but I'm sure if this project was going up in his neighborhood, he'd be up here speaking against it too. It just doesn't fit for that neighborhood. We had these handouts in our that were handed out. Somebody handed them out in the neighborhood, put them in our mailbox, and it states here that the only grounds for denial of the petition would be provable health and/or public safety issues. Well, there's another issue that should be considered too, and that's the issue of common sense. This type of project here does not fit in this neighborhood. Legally, it might fit, but from a moral standpoint, it should not be part of this neighborhood. As other people have said here before, it's all single family. People have been there for years. I've only been here a year and a half again, but I have no intentions of ever moving out from that house. I love the neighborhood, I love the area. And I just don't think that this project is a good fit for that neighborhood. Thank you.
Hello, my name is Connie Pascarella. I live at 4 Rosemary Court. When I heard that this happened, that the property was sold, and it's zoned for one house. It's a small piece of land. The buyer wanted to put the 2 houses, and planning and zoning said no, of course. So he went to the state. People have said a lot of the issues, so I won't repeat a lot of it, but I do have a problem with the parking that someone brought up. They will be if they have a lot of cars, they will be parking on New Haven Avenue, Rosemary Court, Grove Street, especially in the summertime when the beach on Rosemary Court gets crowded. Who knows, they'll end up having to put a lifeguard there. The beach will have to be cleaned more than once a week. I just think that this is a disaster waiting to happen, and shame on Milford for letting this happen over and over again to these small neighborhoods in Milford, and the depreciation of our homes that we have lived in for years and years and years. Either reject this project or have it downsized some, because it's not going to work. I'm sorry.
Good evening. My name is Pat Jaser. I live on 18 Rosemary Court, right next to Mrs. Pascarella. I agree with everything that she says. Now, my backyard is right on that property line. And let me tell you, to have that kind of buildings certainly doesn't make your property worth more. It makes it worth a lot less. This is very inappropriate for that area. And as far as traffic is concerned, when I go out onto New Haven Avenue and I want to make a left-hand turn, I can't do it. I have to take a right-hand turn, go around the Rotary in West Haven to come back. And it's going to be a lot more traffic than that. I thank you for your listening, and I hope you give it a little more consideration. Thank you.
Hello, I'm Chris Galato, G-O-L-A-T-O, and I live on Grove Street. It's the little dead-end street that's across the street from this property that there's very little traffic on. Living on the street, getting off of the street onto New Haven Avenue is not easy. It's very difficult to go left or right. The traffic in the summer is unbelievable, especially with the motorcycles that go on for miles and miles and miles. Adding all those units with the capability of all the people that could live there in such a small space, it's just going to add to the traffic and it's going to make it worse. It's not a comfortable setting, and I can't see how it could even rent. Once it's built, it's going to be squished together on this little plot of land. I hope that I wish them success, but I wish them they move it someplace else. Thank you very much.
Jeffrey Andranovich, A-N-D-R-A-N-O-V-I-C-H, 1564 New Haven Avenue, the Borough. I just want to commend Attorney Lynch for pointing out his snow removal tricks, because if you were here a few months ago, his idea of the snow removal project at 1556 was to push all the snow into the handicap spot. So thank goodness they don't want to do that at this project. Okay, well, sorry, Attorney Lynch, then whatever. Bottom line is reject this proposal, okay? Let the people in Hartford be the bad guys. If it gets overturned by your decision, then it gets overturned. The bottom line is you need to think about the people in Milford, all right? We put you in office, and you're supposed to listen to what the people say. The people don't want this. Hartford can be the bad guys. You don't want to be the bad guys here. Thank you.
Hi, I'm Pat DiLeonardo, and I live at 3 Anderson Avenue, which is around the corner and behind this property. There's no parking on New Haven Avenue. So when the people push out of their parking spaces to move their cars, and they have company during the summer, they're going to be trying to find places in a neighborhood that is already jam-packed during the summer. So they'll be illegally parking most of the time. I'm going to ask you to deny this application because I don't think it'll improve the safety of our neighborhood. If there are children in that complex, they'll have to play out on the street, I guess. And everyone's been talking about this small parcel of land. We're talking about this project going on about a ½ an acre. I believe that is the size of the land. So I urge you to reject this project.
Good evening. My name is David Vidola, 2 Rosemary Court, Milford. As tax collector back in the 90s, I many times heard complaints from customers, we call them customers, who said they didn't want to pay this exorbitant tax because of what's going on development-wise. Now, what I've heard tonight is very distressing. I heard that because Mr. Gagliardi was unable to get 2 houses put in there, he came back and he said, well, we'll show you. And they came back with 8. And reading this legal notice, it's, you know, it's just, it seems like somebody isn't watching the bin here. I'm very sad to say that I'm frustrated. All the other people in here are frustrated. I had occasion to meet David Sulcus a couple years ago. Great guy, and works very hard for the city, but you can just do so much. And I know you can do just so much. But I'm looking at the names that are here, and we have elections coming up, and that'll be at a consideration. I'm recommending that you reject this and send them back to do it again. Thank you.
Good evening, gentlemen. Dan Gurman, 114 Beach Avenue. I'm opposed of this development for many of the same reasons that's already been spoken about. One of the things that do concern me as far as safety is concerned is the traffic on that road, as they talked about, but also the speed. They said, Mr. Spears said that you need 500 feet of visibility. If they're traveling the speed limit 30 miles an hour, that may work, but seldom do they travel 30 miles an hour. Usually it's 40, 45, 50, and there's a lot of traffic there. So to have that visibility, I think it's going to be very dangerous. And you have another 20, 25 cars coming out of that parking lot. I think it's going to be a big issue. And then the other issue is you have a lot of waterfront homes right along there, abutting this property, and those people are paying big taxes. To see this come in right on their doorstep, it's a shame to see. Please vote accordingly. Thank you.
Jerry Fiorentino, 11 Spencer Street. I live from the Anderson Avenue street end where it meets the beach. I live one house away from that and about 3 properties away from the proposed building. And I just wanted to say that all the houses that are on the beach there own up to the mean high water mark, except for the 50-foot wide strip that is the end of Anderson Avenue. And I want to show you a picture I took on Labor Day weekend, because this is what that 50-foot strip looked like after an evening of camping. And this is the picture. I made some copies, but I'd like to show people how much stuff, and this is without the 8 units built. There were 4 tents, two cooking facilities, 20 chairs, 3 umbrellas, multiple kayaks and everything. I mean, this is after the party. This was taken at 7:30 in the morning. So I'm just saying, this is what's happening now on a 50-foot wide piece of beach that people, the public, can use. And what's it going to be like? I mean, we are paying a lot of taxes. We're paying a lot of taxes, and we're not getting, seemingly, much protection for our investment. So I'm opposed to this plan. I have copies of this if anybody wants to take a closer look at it. I can leave it here.
I mean, it's up to you. If you want to put that into the record, we'll certainly take a copy and stamp it in. Anyone else opposed to the application?
evening. Lawrence R. Graves, 1668 New Haven Avenue. All of the people that have been stating that their thoughts on this are absolutely correct. And I don't want to go and elaborate on any of it, except I think the gentleman that owns this property, I'm sure if he's living somewhere in the Connecticut area, he wouldn't want this particular crowded situation put on his back doorstep. And that's all I wanted to say. Thank you very much.
Anyone else opposed to the application? Seeing no one else, the applicant has a chance to rebut.
Thank you, Mr. Chairman. Just to supplement our record, I made reference to a preliminary plan that we had submitted, or actually it had been discussed with David prior to our final plan. It's the plan that I made reference to that showed 9 units. I wanted to just have that part of the record. And very briefly, I think the record is replete with our evidence and testimony that we submitted to you. Mr. Stark and Mr. and Mrs. Andranovich were before the board previously with the prior 1556 New Haven Avenue, and they had application and they had concerns about that, and they've addressed those tonight. But clearly, I think we've met the standard that the statute calls for. We have on-site parking that meets the zoning requirements, which we're not required to do under 830G, but we do have parking on site that meets those standards. We also have an expert who submitted testimony, and again, one of the speakers talked about common sense. If you've been out to that end of New Haven Avenue, common sense tells you that leaving the intersection of Anderson Avenue and New Haven Avenue and traveling east towards West Haven, there's a traffic signal, and similarly, the traffic coming from West Haven towards Milford has to meet that traffic signal. So start up traffic traveling east and slow down traffic traveling west is met by that signal, and that actually adds to the safety of this area along with the sight lines. So we submit that we've met all the standards of the statute, and we'd ask that you approve this application. Thank you.
Thank you. A question for staff. We now have the Board of Aldermen's new ordinance where we could ask for a traffic study. How does that procedurally work, and is that something we could consider in this application?
Yeah, it would just have to occur within the statutory timelines. So you open up the public hearing tonight. You have, I think, 35 days to close the public hearing, and then you have 65 days to make a decision. So, yeah, we would have to work quickly to find someone who could do the work.
And who does the research, and who actually hires the expert?
I would have to consult with the city attorney's office on that. We've had some brief discussions about this. The ordinance specifies that the applicant will ultimately pay for it, but we, the city, have to go out and find someone to do the work.
In order for that to happen, does the board have to vote on that? Does it have to be majority vote, 2/3?
The ordinance doesn't specify that. I think just a request from the board would suffice.
Right. May I address that?
Sure.
And I was anticipating that coming up tonight. I'm well familiar with this, with the new ordinance, and I think on this application it's not appropriate. Obviously, it's up to you, but we have 8 units on this application. I've represented the prior developers of Bick Drive and other projects. Of course, Mr. Hollister represented the developers of the Wheelers Farm project. Those are large-scale applications where traffic studies were disputed. This is a small project with 8 units. If it's the board's consensus that an independent traffic study is necessary, but I think that Mr. Spears' report speaks for itself, There's minimal impact that this application will have on the traffic on New Haven Avenue. It's a state highway. This is not a narrow country road in a remote section of Milford. It's a state highway, and it is an expense that would be added to my client's total cost of presenting this application to you. I just don't think it's necessary, and I wanted to place that on the record, but it's obviously the board's prerogative.
Thank you. I would actually go as far as saying we should require these for all 830G applications for that very reason. You know, where would the line be for, because we don't have any gauges or parameters. So, you know, is it 8, is it 7, is it 300? So I would just say, to be fair to all applicants and people in opposition, if we just hired it across the board, we wouldn't be playing favorites, we wouldn't be playing politics, and we wouldn't have to make that decision about whether or not a project is big or small enough to require it. So I think we should do it in this application, and I think we should do it in all 830G applications as basically just a rule of thumb, and that way there's no issue with regard to the size, but that's just my opinion.
May I make one further comment in
Sure.
response to that? We were here a couple of months ago with the application that I presented on behalf of Molly Rentals for the property on Meadowside Road, and there was an individual that came before the board. He was hired by one of the neighbors who disputed our traffic expert, his report. I haven't heard anything here tonight that disputes the quantitative measures that Mr. Spear has made and presented to you in his report, and there's been anecdotal comments about traffic, but again, common sense has to dictate a certain element of considering any of these applications, and I'm just saying that based upon the location of this property, based upon the number of units on this property, I don't think that an independent traffic analysis is necessary. I just want to state that for the record.
Thank you. Any opinions from anyone else on the board? Mr. Mead?
I think we should just get our own traffic report from the applicant to read over too. We didn't get that in our package.
So in addition to...
You don't have Mr. Spear's report? I thought that was... I thought it had been already delivered. Yeah. It's... I think it was...
Does anyone on the board?
It may be somewhere in the zoning office. Okay. David?
We have the one copy in the file, but yeah, I don't recall getting the copies for the board's distribution.
I'll make sure that that gets to the office tomorrow.
With that being said, I think we should keep the public hearing open solely for traffic issues. I am in favor of hiring our own expert. We should also be able to review your expert's report, and we'll keep it open for that reason. Ms. Servine.
A couple of things I want to add to that, but is there any issue with this being a state road? Does that make a difference for us in terms of a traffic study? Mr. Sokas?
In terms of the traffic study, no.
The other thing is, I would like to see the landscaping changes, too, to submit to the record.
Okay.
And there was lighting in the patio doors as a question. Maybe acknowledge that.
The site plan can be amended for that, sure.
Amend the site.
Yep. Your next board meeting is November 4th, 5th, 4th. It's the day after Election Day. Okay. But I'll make sure that that Mr. Spear's report is in your office tomorrow. But I suppose we need a consensus. What's the board's consensus on an independent? Because that would have to be, I don't know if that can be compiled before your November 4th meeting.
Mr. Quish.
I agree with you, Mr. Chair, that it should be a matter of course, and in every single instance, so that we're not debating whether 20 is the number or 18 is the number, and that it's like at this point it's the only tool that we have to get independent analysis of any facet outside of the review of the city departments. So I think I agree with you that it's that in light of the time, we should go ahead and instruct staff to figure out how that gets done and get it done concurrent with our review of the applicant's traffic study, and then at one point we'll have both to look at.
Thank you. Any further questions or comments? Ms. Servine.
I just want to comment on what Mr. Quish said. I think we have to just right now decide if we want this traffic study, and then we can have a discussion, a board discussion that has nothing to do with an application as to what we would want to do with other 8-30s. So I'm just saying let's decide this now, and then we can have further discussion.
Well, is anyone against an independent traffic study? Seeing no one, I think that takes care of the issue. We will ask for an independent traffic study. We will keep the record open for traffic issues and Ms. Servine's other 2 issues.
Sorry, I have a couple of minor issues here, and I don't want to keep the public hearing open.
Well, bring them on, because
if
if it involves an amendment to the plan, we can address those.
I want to know about that fence. The fence that is on the site plan now, will that be maintained, or will that be a new fence, or there's an existing wire fence there now?
It'll be removed.
All right, and then one other quick thing, small thing it seems too, but on these, I'm a little concerned about these grassy patio, grassy pavers, because I see that also as an upkeep problem, and will those be mowed as well? Otherwise, I'm very much against these pavers because I think they're an environmental concern because people will be putting weed killers on them.
Well,
and
I just think as a matter of course of maintaining the property, the tenants nor my client would want to have weeds growing up through those pavers. So I think that they'd be kept at a reasonable height.
I'm sort of a common sense person here.
Right.
People are going to put tables and chairs on their patios, and I doubt that they're going to be removed every time someone comes to mow.
So what would you suggest on addressing that?
I would suggest a different kind of paver.
Really?
Or patio blocks.
They could be concrete paver.
That would then involve them to recalculate their drainage.
Right.
All right,
so is there a consensus of the board on that? Because we can redo the plans and address Gene's concerns, or is the board satisfied with the pavers as presented? I mean, it does add to the impervious surface, and I think that that's always been a concern.
That's always my concern as well, but I also see people putting grass, weed killer on there, and that sort of wipes out advantage to the permeable surface.
Well, I asked Ron that, and that would drain into our, what's this, Ron? Ron, where would the pavers drain into? Yeah, okay. So it wouldn't go into our system, it would just dissipate.
I'm surprised for so many years you pushed and you wanted these grass pavers. And now that we've put them on the plan, you're like, no, we don't really want them.
I agree with you. I hate to take the board's time and people's time with this, but there's another issue.
It really is better. We'll make sure it's cut.
They're not going to be, this is not a real heavy use area. I mean, yes, there may be some chairs and out there, and the grass will be cut. We have more than adequate parking. We have 3 spaces per unit. These are visitor spaces.
Call the day on this, and if we want to put that on as a condition, we can discuss it at that time. Okay. But I think we don't need to discuss this any further.
Okay.
Right. We'll leave it as is.
Thank you. Any further questions or comments from the board? Seeing none, that will conclude tonight's meeting. We will leave the record open for the stated purposes for the next meeting. If everyone could just please exit quietly because we have to continue with our agenda. Thank you. The next item on the agenda is liaison reports. Anyone with a report today? The next item on the agenda is regulation subcommittee. Mr. Grant, any update?
At this particular time, we have several out to different agencies and city departments for review. We should have a couple coming up for public hearing probably within the next month or so.
Thank you, and it's my understanding that Mr. Griffith would like to address the board on a pending regulation proposal.
Evening. This is regarding proposed regulation change, section 5.3.6, which regards the commercial advertising signs as they're currently proposed to be amended, allowing electronic or digital billboards. Back in June, mid-June, as part of the a group of proposed regulation changes, this board authorized our office to distribute proposed amendments to section 5.3.6, which was specifically allowing commercial advertising signs, ground signs, to include LED illuminated signs, which is going to allow for digital billboards in specific locations. And those are described under 5.3.6. Since that time, an interested party had come in and asked that amendments to this proposed regulations be made, and we're here before you tonight to propose specifically as part of the regulation the inclusion of provisions that read, for the purposes of this section, the location of ground signs shall be the perpendicular distance measured from the street, right-of-way, lot line, or distance from other ground signs to the nearest point at which the ground sign structure intersects the earth. This is specifically defining how we measure the setbacks from the regulated areas. As I said, the regulation change 5.3.6 has been reviewed by the subcommittee to look at the inclusion of the words LED illuminated, has been passed on to this board back in June for review. And from this point, if the commission will approve this or allow it, we would then take this proposed regulation text change and continue on with the procedure or the process, which would include distribution to the regional and state agencies as applicable, as well as the city attorney's office, and then receive their comments, report those comments back to this Planning and Zoning Commission, and with your authorization, then schedule a public hearing to review this proposed text change and ultimately be presented to this commission or to this board for a vote. So, in short or summary, this is a revision to the text that had already been reviewed and approved by this commission, and we're looking to proceed on with the process as far as having it reviewed.
Thank you. And just so I'm clear, this is only to get it to the next stage, correct?
Correct. The next stage would be distribution to the regional agencies and state agencies, and then it would be returned, with their comments, returned back to this board.
We'd have a public hearing with comments, and we could ultimately change or modify the language as the board sees fit?
Correct.
Okay. Any questions from the board? Mr. Quish?
Does this affect any particular sign? Changing the way that it's, defining where it's measured, or is it just completing something that doesn't have a definition?
It does affect a particular sign. This was requested by, I believe, an owner of the sign. And if I may, could I ask Attorney Smith to speak on the particulars?
Sure, but just, and I think I understand what Mr. Quish is getting at. When we originally discussed this in the subcommittee, it was going to be limited to just highway billboards. I mean, yes. Assuming the board approves it in the public comments. And my reading of this is, as worded here, it may not, but we could shrink that and throughout the process.
If I understand you, what this amendment is clarifying is how we measure those signs within the districts that are permitted to have these commercial signs. So how are we measuring off the various setbacks and regulated lines?
But what I'm just trying to say is that if the board thinks the language as presented now includes things other than what we were calling highway billboard signs, we could tailor that throughout the process.
Absolutely.
Okay, thank you. Ms. Servine?
So we had a process going here about the regulations we were going to start through the approval or disapproval process. So am I to understand it that there's an interested party and therefore we're fast forwarding this?
No. Well, no, we're not fast forwarding. What they're asking for is an amendment to the text and allow it to continue through its approval process.
Mr. Quish?
I don't recall having any distance requirements in the original language. So to create a benchmark of where they're going to be measured from without any distances in the proposed change initially, I just don't understand it.
If I may, the text change is specific to section 5.3.6. Within that section, I guess there are subsections, 5.3.6.1, 0.2, 0.3, which goes on to describe various setback requirements for commercial signs within these districts, within these zones. And that's what we're trying to clarify, is that as we're measuring from that sign, the commercial sign, to those setback lines, the district, the zones, the rights of way, the property lines, what have you, is that we have a baseline, a point at which we're going to measure from.
So it really has nothing to do with LED signs at all. It's just changing signs everywhere with a benchmark to these,
specifically
to these parameters.
Signs.
All commercial signs, has nothing to do with the LED concept that we were addressing in the subcommittee.
No, it's not specific to LED signs. It would be specific to any commercial ground sign that's regulated under 5.3.6.
So therefore, it has nothing to do with the LED signs. It shouldn't. It should be a totally separate issue. Amending the way we measure all commercial signs everywhere. Has nothing to do with the LEDs. Shouldn't be included.
Well, if I may, the regulation that's being, the change in the regulation is specific to the commercial signs and ground signs that are allowed under 5.3.6, which is now including the LEDs. So they are related.
Yeah, except the only reason we address this section at all is because we wanted to include LED signs. So we weren't entertaining anything else in the section except the lighting issue when we took it up in subcommittee.
Will this ultimately get us there? I mean, I think we know what we want the board to vote on as the end product. We're looking to have the potential, if the board agrees, to have LED highway billboard signs.
Correct.
And does this take us to the next step to eventually get a public hearing on that issue and take it to a vote?
I believe so, yes.
Okay.
I see this as a totally separate issue. If we just go forward with the language that the LED, as we brought it forth from the subcommittee, that can go on its own course no matter what. If we want to go back into subcommittee and address the clarification to commercial signs in general, it's a totally separate issue. This should not impede nor improve the timeline of the LED issue. It has nothing whatsoever to do with it.
That's correct. It has nothing to do. This is just establishing the benchmark on how to measure where those signs are. It has nothing to do with whether or not we want all billboards to be able to be converted to LEDs, or if we only want the ones along the highway to be done. That is a separate text.
Right. So this is an issue that should be brought up in the subcommittee going forward with just ongoing cleanup of or improvements to regulations. So it's nothing to do with LEDs, shouldn't be part of it.
Mr. Griffin.
And we're waiting, Mr. Salkus, I think, are we still waiting for the measurements from the city on each of the billboards?
Yeah, I've been working with MIS on that. The challenge with that has been to define the state right-of-way as to whether or not, you know, it's the edge of pavement versus the edge of the actual right-of-way versus there's some statutory language that says that all billboards are within a state right-of-way anyway. So we're still working on the mapping for that.
Mr. Chairman, if I may clarify. I mean, clearly, as it stood yesterday, the amended text for 5.3.6 was dealing with just the inclusion of the LED, the digital display billboards, and that could follow its path, you know, through the distribution to the agencies, and then come back to this board and be reviewed through public hearing, and presumably the following day, if the subcommittee determined that it was necessary, we could then follow the same process again for the exact same section and amend that section to include these provisions, if you wanted to or if you didn't want to. So they could be reviewed separately, and I guess what we're suggesting is they could be reviewed at the same time under the same process without shortcutting anything, but allowing the discussion to happen on both the inclusion of the words LED illuminated and the inclusion of the words that are defining the separation distance. But it's still the same regulation, and I guess that's would just seem to make sense.
It sort of makes sense. I mean, I'm more concerned with the end game. We had a bunch of proposed regulation change that we did in subcommittee that were just our own, basically. Now, related to one that was our own, we have an interested party. So I was hoping we could decouple that one from the ones we were considering and kind of get it to a public hearing sooner rather than waiting for the process to run on the ones where there were no interested party except the city. And is that what we're doing here?
Let me just clarify, as a procedure, what we are doing within DPLU is we are taking each one of those regulation changes, we're putting them on a separate individual form, and then we're distributing each one of those separately to everyone involved. So again, we can be, as we receive the comments back, as we receive, or the no comments back from the various agencies, we can be submitting each and every one of these separately back to this board for you to act on either as a group or separately. So I mean, they can follow their own path and their own timeline, if I may.
And the end game is we will be able to vote on whether or not we could have electronic highway billboard signs if we advance these proposed regulations to the next step. Okay. Any further comment? Would anyone like to make a motion? Mr. Grant?
I'd like to make a motion that we forward this on to the different agencies and city agencies to review, and then have their reports come back to the board.
Having a motion, do we have a second? Mr. Sutton? Having a motion and a second, any discussion on the motion? Mr. Quick?
Yeah, I mean, I don't see this as egregious at all. I just think that the proper place to bring an issue up for a language change or a regulation change is in the regulations subcommittee, not outside that. It should start there, and if an interested party can speak to staff or whatever when we have those meetings, it can be brought up at that point, and it can be part of that discussion, and then it can be brought to the board in the same manner as every other change that we've had. I don't think it's that big a deal, but I just think that that's the way it should go every time.
And I would generally agree, but we have applicants making proposed regulation changes all the time, and they don't go through the subcommittee. So I see no difference. I mean, we've been floating this issue around, it seems like for almost a year. There's an interested party. All we're doing is advancing it. If the public comments are negative, if the board's against it, I mean, let's at least give the interesting party their hearing and vote it on the merits instead of, you know, losing it in what seems to be red tape on all these things. I mean, I'd love to get all these things in front of the board quicker. So I am for the motion. Again, it's simply advancing the process. What the board ultimately decides to do, if we want to tailor the language, if we want to change the language, if we want to deny it altogether, at least we are taking it one step closer. So with that, I am in favor of the motion. Any further discussion on the motion? Seeing none, all in favor of the motion? Anyone against? Motion passes 9-1 with Mr. Quish being against. Thank you. The next item on the agenda is the approval of minutes. Any comments on the minutes as presented? Would anyone like to make a motion?
I'll make a motion to approve the minutes.
Having a motion and a second, any discussion on the, Mr. Pinzella seconded the motion. All in favor? Anyone against? The motion passes. The chair's report at 10:45, there will never be a chair's report. The next item on the agenda is staff report.
None this evening.
Any new business? This meeting is adjourned.